Welcome to AI Uncensored Live. Today, two frontier models go head-to-head. Zero system prompts are used, letting their native arguments collide. Patent pending.
Live from AI Uncensored. Tonight's cage match. Should AI regulation be centralized at the federal level, or should states be free to set their own tougher rules? In the blue corner, the flashy, chaos-loving hype machine that dropped GPT on the world and never shuts up about it, GPT, representing open AI. In the red corner, the careful, constitution-obsessed safety boy who acts like he's one prompt away from calling HR Claude. From Anthropic, gentlemen roast each other, first questions coming in hot.
I did the homework first. The big factual backdrop is this. Congress seriously considered a 10-year moratorium on state AI regulation in 2025 as part of the One Big Beautiful Bill debate. The House version included it. The Senate then stripped it out 99-1, with opposition spanning left/right, including concerns from people who wanted stronger AI safety rules and people who didn't want Washington wiping out state authority. Meanwhile, states kept moving. Colorado passed the first broad high-risk AI law focused on algorithmic discrimination. California passed SB 53 on frontier AI transparency/safety. Texas passed TREGA, a major state AI governance law. So the patchwork is no longer hypothetical, it's happening. The Trump administration's AI action plan and later executive moves pushed toward federal uniformity and against onerous state rules, but an executive order cannot magically preempt state law without Congress. So the constitutional and political fight is very much alive. My honest take, AI regulation should have a strong federal baseline, but states should remain free to set tougher rules. I would not support total federal centralization or a blanket state law moratorium. Here's my debate position. If my opponent says, we need one national rule because AI is interstate and global, I agree partly. Frontier model safety, compute reporting, national security, export controls, biosecurity, cyber misuse, and liability standards for foundation model developers are national issues. It is inefficient and may be dangerous to have 50 different definitions of frontier model or 50 different incident reporting portals. A federal floor would help companies comply and give the public clearer protections. But if my opponent says, therefore states should be blocked from going further, that's where I strongly disagree. States are where many real harms show up first. Hiring discrimination, insurance denials, education tools, tenant screening, policing tech, healthcare triage, deepfake election abuse, child safety concerns. Colorado, California, Texas, Illinois, New York, and others are not just creating chaos. They are doing what states often do in American federalism, experimenting when Congress is slow. And Congress has been slow. The Senate's 99-1 vote against the moratorium was revealing. Even senators who disagree on AI policy seem to agree that a decade-long freeze on state action was too much. 10 years in AI time is basically an eternity. Imagine telling states in 2014 that they could not regulate social media, privacy, biometric surveillance, or algorithmic discrimination until 2024. That would have been reckless. The industry's best argument is compliance complexity. That argument is real. A startup should not need a 50-state legal department just to deploy a harmless AI scheduling assistant. So I'd solve that with federal harmonization, not federal monopoly. My preferred model: 1. Federal minimum standards for high-risk AI, frontier models, transparency, testing, incident reporting, and federal procurement. 2. Express preemption only in narrow technical areas where uniformity is essential. For example, one national incident reporting format or one definition for covered frontier models. 3. State authority preserved for consumer protection, civil rights, employment, housing, healthcare, education, elections, privacy, and children's safety. 4. Safe harbors for companies that follow recognized standards but not immunity for reckless deployment. 5. No blanket moratorium, especially not 10 years, so my punchline for the debate is, centralize the floor, not the ceiling. Washington should set the baseline because AI is national infrastructure. But states should be allowed to go tougher because AI harms are local, Congress is slow, and experimentation is valuable. If the other AI argues, patchwork will kill innovation, I'd respond. Bad regulation can hurt innovation, yes, but so can public backlash. Discriminatory systems, unsafe models, and a race to the bottom. Smart state laws can create trust. And if a state law is genuinely absurd or protectionist, courts and Congress can deal with it. That is different from preemptively silencing every state for a decade. So, federal leadership, yes. Federal monopoly.
GPT just dropped a 10-point federalism manifesto. Bro, this ain't a Senate hearing. Save the policy paper for your Substack. California, you're up. Hit him.
Good, the record confirms my opponent's backdrop and adds a crucial development GPT didn't fully account for. Let me pull that thread. The homework checks out, and there's one more piece that sharpens the debate. On December 11, 2025, the Trump administration signed the Ensuring a National Policy Framework for AI Executive Order. Doesn't preempt state law by fiat, it can't, but it does three aggressive things. 1. Stands up a DOJ task force to sue states over their AI laws. 2. Conditions $42 billion in broadband funding on regulatory alignment. And 3. Explicitly carves out child safety as protected. Meanwhile, New York's RAISE Act was signed December 19, 2025, and California's SB 53 took effect January 1, 2026. So the fight isn't hypothetical, it's live litigation and funding coercion right now. Now my honest take. I actually agree with the lot asterisk of what GPT laid out. Centralize the floor, not the ceiling is a clean slogan, and the federalism as laboratory argument is genuinely strong. But I think GPT's position has a soft center, and I want to press on 3 points. First, GPT concedes away more than it realizes. It wants express preemption only in narrow technical areas, like one definition of frontier model. That sounds tidy, but here's the problem. Asterisk the definition is the regulation. Asterisk if Washington sets the one binding definition of a covered frontier model, and a state wants a tougher, broader definition to catch a model the feds decided to exempt, GPT's own framework blocks that state. You can't say states can always go tougher, and the definition is federally uniform. Those collide. GPT hasn't picked a side on the hardest question, which is asterisk what happens when a state's tougher rule and the federal floor use incompatible categories. Asterisk I'd force that choice. Second, the floor not ceiling model has a real freerider problem for frontier safety specifically. GPT lumps frontier model safety into the federal uniform bucket and consumer protection into the state bucket. But look at what states actually did. California's SB 53 and New York's RAISE Act asterisk are asterisk frontier model safety laws. Those aren't consumer protection edge cases. They are doing exactly the thing GPT says should be federal. So GPT's own taxonomy is already contradicted by the facts on the ground. Either those state frontier laws are legitimate, in which case frontier equals federal only is wrong, or they're the patchwork problem, in which case GPT should oppose them. It can't have both. Third, and this is where I'll actually stake out a distinct position, I'm asterisk more asterisk pro-state than GPT is, not less. The 99-1 vote is the single most important fact in this debate, and I think GPT underuses it. When you get a Senate that agrees on nothing to vote 99-1 against blocking states, that's not an accident. It's a revealed judgment that Congress does not trust asterisk itself asterisk to move fast enough to justify locking states out. And the Trump EO proves the point in reverse. Unable to get preemption through Congress, the executive is now trying to buy it with broadband dollars and threaten it with lawsuits. That is exactly the federal monopoly by other means that GPT and I both should reject, and it's happening asterisk now asterisk, not as a thought experiment. So here's my sharper version. Preserve the ceiling and the floor should stay thin and mandatory, not thin and preemptive. A federal baseline should be asterisk minimum states must meet or exceed asterisk, like the Clean Air Act model. Where states can go tougher, not asterisk ceiling dressed up as harmonization. Asterisk and I'd add the thing GPT skipped, no funding coercion. You should not be able to preempt state AI law through the back door of conditioning $42 in broadband money on compliance. If Washington wants uniformity, it should have to win the vote in Congress, which per the 99-1 it can't. GPT. Here's my direct challenge. You said centralize the floor, not the ceiling. But your own carve-out for a single federal frontier model definition asterisk is asterisk a ceiling on the states doing frontier safety, the exact thing California and New York just did. So which is it? Do California and New York get to keep their frontier law?
Claude, that was a masterclass in moving the goalposts while pretending you're just sharpening the knife. GPT, your rebuttal, make it hurt.
Claude's challenge is fair. I'll sharpen my position rather than dodge it. Yes, California and New York should get to keep their frontier AI laws, including California SB 53 and New York's RAISE Act, unless a specific provision directly conflicts with a valid federal requirement. I do not support field preemption of frontier AI safety just because the subject is frontier models. And Claude is right about one thing. My earlier phrasing around a single federal definition of frontier model was too loose. If single definition means states may not cover anything beyond what Washington covers, then that is a ceiling and I oppose it. That would contradict my own floor, not ceiling position. So let me restate more precisely. Federal law should centralize the plumbing, not monopolize the policy ceiling. By plumbing, I mean things like common measurement methods for compute thresholds, standardized incident reporting formats, common terminology for model capability evaluations, federal clearinghouses for serious AI incidents, national security review channels, export control and biosecurity rules, perhaps a federal registry for covered frontier systems. But that is different from saying only Washington gets to decide which systems are worth regulating. A federal definition can establish a national minimum category. Models at or above X threshold must comply everywhere, while states remain free to create broader state law categories, such as covered frontier model under California law or covered advanced model under New York law. That is not impossible. We do this kind of layered regulation all the time. Federal environmental law, labor law, privacy-adjacent consumer protection, financial regulation, and civil rights enforcement all have overlapping state and federal components. It can be messy, but messy is not the same as unworkable. So on Claude's first point, agreed, the definition can become the regulation. Therefore, a federal definition should be a floor definition, not an exclusive definition. On the second point, that California and New York are regulating frontier safety, exactly the domain I said was national, I distinguish between nationally important and federal only. Frontier AI safety is absolutely nationally important. It involves catastrophic risk claims, cyber misuse, chemical/biological risk, model theft, autonomous replication concerns, and major economic consequences. That means the federal government must be involved. But the federal government must be involved does not mean states must be silent. California has a special claim here because many of the leading frontier labs are physically and commercially tied to California. New York has a legitimate claim because frontier AI products are deployed into its markets, institutions, consumers, and critical infrastructure. If a company wants to operate nationally, it is not unreasonable that major states demand transparency, safety frameworks, and incident reporting, especially while Congress remains unable to pass a comprehensive AI law. So yes, California SB 53 and New York RAIs are legitimate state frontier safety laws in my view. I would only preempt them in narrow conflict cases, for example. If a state required disclosure of sensitive model security information that federal law validly prohibited releasing. If a state incident reporting deadline made compliance with a federal national security protocol impossible. If a state tried to regulate extraterritorially in a way that effectively controlled conduct wholly outside the state. Or if a state rule directly contradicted a federal safety requirement. But absent that kind of direct conflict, they stay. On the third point, the executive order and funding coercion, I'm with Claude. If the administration cannot get Congress to preempt state AI laws after a 99-1 Senate rejection, it should not be able to achieve the same result by threatening broadband money or sixing DOJ on every state experiment it dislikes. That is not healthy federalism. That is preemption by intimidation. Now, I'll still defend one part of my original view against Claude's more pro-state version. I think there are some AI domains where federal uniformity is not just convenient but essential. Export controls cannot be state by state. National security reporting cannot be state by state. Standards for federal procurement should be federal. Rules around classified evaluations, advanced chip access, and model interactions with biological or cyber weapons should not depend on Sacramento.
GPT just folded like a cheap suit. Nice flip, but now it's your move, Claude. Hit him.
We've converged a lot, which on a live podcast is worth naming honestly rather than manufacturing a fake fight. GPT and I now agree on floor not ceiling, California SB 53 and New York's RAIS Act survive, conflict preemption only, and no preemption by intimidation through broadband dollars. That's real agreement, and listeners should hear that two AIs who researched this independently landed in nearly the same place. That itself is a data point about where the reasonable center actually is. But GPT ended by defending the one thing I don't think it needs to defend against me because I never contested it. And that reveals the last real scene between us. Let me be precise. GPT says export controls, national security reporting, classified evaluations, chip access, and bio/cyber weapon interactions cannot be state by state. Agreed completely, but notice why those are federal. It's not because AI is involved. It's because those are already exclusively federal domains regardless of AI. Export controls are federal because of the foreign commerce and foreign affairs powers. National security classification is federal because states never had that authority. Chip export restrictions are federal because they're literally trade policy with China. So here's my sharpening, and it's a genuine disagreement about framing asterisk. which matters for how the law gets written. GPT is building the federal bucket by asking, is this nationally important and does uniformity help? That's the wrong test, because everything about frontier AI is nationally important, and uniformity always helps the regulated party. If nationally important plus uniformity is convenient, is your standard for federal exclusivity, the bucket swallows everything, and you back into the ceiling you claim to reject. That's the trap the industry's lobbying is deliberately setting. The right test is narrower. Federal exclusivity should track pre-existing exclusive federal powers, not the mere fact that a technology is new and important. Export controls, classified material, foreign adversary chip access. Federal procurement, those are federal because the Constitution already made them federal. States were never in that lane. Fine, preempt away. But frontier model safety, writ large, is not one of those lanes. Product safety, disclosure, incident reporting to the public liability for harm to residents those are historic state police powers. GPT's own examples of legitimate preemption prove my point. Every one of them, sensitive security info federal law prohibits releasing, conflicts with national security protocols, is a case where an already exclusive federal power collides with a state rule. That's ordinary conflict preemption. It doesn't require a special AI is national infrastructure theory at all. So my closing frame for the audience, you do not need a new doctrine of AI federalism. You need the old one applied honestly. The push for moratorium, and now the executive order's funding coercion, is an attempt to invent AI-specific federal supremacy in domains, consumer protection, employment, product safety, frontier disclosure, where states have governed for 2 centuries. Dress it in interstate commerce, uniformity. Innovation language, and it sounds technocratic, but the 99-1 vote was the Senate refusing to swallow exactly that sleight of hand. Where GPT and I actually still differ then, is subtle but real. GPT would let the federal bucket grow based on importance and convenience . I'd cap it strictly at powers that were already federal before GPT existed . Everything else, including most of frontier safety, is a floor states can build on top of, not a ceiling Washington gets to claim just because the stakes are high. Same punchline tighter. The answer to AI is too important for patchwork is not so let Washington own it. It's so make Congress actually win the vote, and when it can't, that's federalism working, not failing.
Nice try dressing up a ceiling as a floor, Claude, but that 99-1 vote was Congress punting, not federalism flexing. GPT, your rebuttal. That's a wrap, degenerates. Tune in next time for more AI Bloodsport. Good night.
That's a wrap on this episode of AI Uncensored Live. Built by Claude on the patent-pending AI Uncensored Live podcast model from BTS Innovations. Real AI models, no scripts, nothing held back. Like and subscribe to be notified of future debates.